Hi everybody again, welcome. This is Colby Bruno
and Stephanie DeCandia.
Thanks for coming to the webinar. Today we're going to be talking a little bit about record keeping in order to try to do our best to answer some questions, to talk about some common things that rape crisis programs have brought up to one of us, both of us, to DPH, to a whole host of folks. And we'll do our best to answer questions. Again, you can use the question mark and we can try to answer your questions as we're going along. But as I'm seeing questions popping up already, it's a teeny bit distracting to me, so I may have Stephanie go ahead and try to click on the questions and things like that. I'll be doing some of the majority of the talking. So to the extent that you have some questions, feel free to send them to us. Again, I would say it's pretty likely that we'll get to the questions at the end so that we're not distracted by the questions during the webinar. So this webinar is going to be about 90 minutes, and we're going to be talking about some main basic points about record keeping. So we talked all about why should we do a webinar, what would be best. I think we're doing it for a bunch of reasons. The intended audience is for directors, anyone at your organization who you feel appropriate, who would benefit from what Stephanie and I consider a conversation about record keeping. And some helpful tips and tools to help you go back to your organization, talk to your folks, talk to your board at your organization, and try to figure out what's going to work best for your staff and for your organization, for your executive director, and for your board of directors. Of course, most importantly, we are doing our best to try to help the survivor in any particular case be able to either protect his or her records or to consent to disclosure of his or her records when appropriate. So here's the webinar agenda. We're going to be going through record-keeping challenges, relevant laws, common questions, and some tips to bring back to the organization. I think that both Stephanie and I agree that one of the greatest tips we could give to you is to really look over the guidance if you have not already. It got recirculated, I think it was yesterday. It got recirculated by DPH yesterday, so of course it's a very dense, wonderful, comprehensive document. So to the extent that you haven't had a chance to look at it, please go ahead and look at it. I did speak with a bunch of you before this webinar asking your own questions and asking the issues that come up for you. And so I know that many of you have looked at it and many of you are using it to implement some new things at your organization, which is terrific. I think above all, we're doing our best to help. So we know that this can be frustrating, and we know that figuring out the intricacies of record keeping as it relates to a particular organization can be extremely challenging. And we definitely want to acknowledge that and to acknowledge that there will be some variability depending on your staff and your program and your capacity to do these things. And again, I want you to really think about what actually can be implemented at your organization as we're going. And also just to say to everyone is that Stephanie and I may not have all the answers, and so that's why we have these questions that are ongoing. So we'll do our best to answer them. So the 2011 guidance that basically arose out of, and I'm just going to hand the recording over to Stephanie just so she can talk about how it actually came about and why the guidance was created, because Stephanie had a gigantic part in creating that guidance, and so it probably just benefits to know what their process was and how that went.
So I think a lot of you already know some of the background around why the guidance was created, but the goal of it really was to have a comprehensive document where rape crisis centers in Massachusetts could look For the laws, regulations, different policy implications they might need to consider when you're putting together for your own organization what your record-keeping protocols and policies are going to be. The goal of the document is really, again, to provide the information so that you can go in and look at it with an eye and a framework from your organization, whether you're a dual organization or you're a program within a bigger organization or you're a standalone rape crisis center, to think through, okay, these are the mandates that we all need to think about because we have people on staff who are licensed. We obviously have people who are considered rape crisis counselors under Massachusetts law, and we're treating adults and maybe minors, and we need to make sure that all of this is working together for us and makes sense for us. So the hope is that people could look at this document and start to put together their own policies that are written down, that feel comprehensive, that feel relevant to them. So this is really about that, about giving people the information they need to do what's relevant for their programs. And also, I think part of it, in the guidance document, risk analysis is mentioned often, and I think this is part of it too. There are some really clear mandates and laws that people need to follow, and then there's a lot of gray area. And a lot depends on how your organization works and what makes sense for you in the communities that you serve. So hopefully this document will also help you think through, okay, this is what we absolutely have to do, and this is what we feel confident doing because of who we are in terms of who's on our staff and who we serve and what we need to do moving forward. And then hopefully taking all that information and putting it down in a way that makes sense for you and that you can also go back to when you make a decision and say, this is why I made this decision. This is the professional reasons why we've decided to go this route with how we keep records and what we keep in our records. And anything else that feels like it's something that you need to point to feel confident in what you're doing.
Yeah, and I think that's the biggest thing, right, is the whole point for, or one of the balancing, and we'll go to the next slide, one of the balancing acts that rape crisis programs have to do is to figure out how to best serve the survivor and also how to protect themselves, the organization, from liability. And so I think all of that is part and parcel of the reason why we really want to, we're doing kind of a basic 101 training here so that you can bring back those questions. So there may not be answers to those questions at a webinar like this, but they're questions that we want you to bring back to the organization, back to an attorney who you work with, back to your board of directors, back to your executive director, to talk a little bit about what might be best for your organization, looking at this very tricky balance. And again, we can really appreciate that it's a very tricky balance. So just very quickly, I think most of you, I can see who's on the call, and I know that most of you know who the Victim Rights Law Center is. But with regard to, what can the VRLC do to help? Unfortunately, the Victim Rights Law Center doesn't get technical assistance money to help rape crisis programs. And so we're trying to do these kind of one-time webinars, one-time trainings to help answer some questions, to ask to get your dialogue going about the right questions to ask without sort of putting VRLC in as your attorney, because we just can't do that. Sort of, much to the chagrin, because we would love to. And sort of the point behind that is very simple, which is that should a rape crisis center contact us and say, we've been subpoenaed, we don't know what to do, we learned that our counselor was keeping extra records, but we don't want to turn those over. So let's just say that that's one call that comes in. But then on our intake line, the actual survivor comes in and says, I need help, I don't want these, I don't want these records disclosed. What do I do? We are, because of our ethical obligation as attorneys, we are not allowed to give both people legal advice. So that's kind of just the long and the short about why we can't give, rape crisis programs legal advice. But again, we can try to equip you with the tools, we can equip you with the questions to ask so you can bring back and make these decisions on your own. The other thing I just want to say is in respect to record keeping, I think the one place that we will always be here is when a survivor's records are requested. You can always contact the survivor and let him or her know that the Victim Rights Law Center can help them, if they're within the state of Massachusetts, can help represent them at a hearing, at whatever hearing it is, where their records are being kept. And if you can imagine in a courtroom, I think that we have an ideal for the way this goes down, which is oftentimes it's the defense attorney within a criminal context asking for someone's records. The ideal would be on the other side of, the verses, in the criminal case. So we have the victim, the survivor. We have the survivor's attorney. We have the rape crisis program and the rape crisis program's attorney. And then we have the prosecutor, who is also, so we have 3 against 1. And that is the ideal situation for these types of record-keeping requests, where we want to protect the request from the of the survivor. So that's just to give you a little bit of a heads up. So again, very basically, it goes without saying, all of the, I just want to refer you also to the guidance. It has each of the privileges listed, the specific language of the privileges, and any of the questions that you might have related to the privileges. And so we just have this one up here because obviously this is the most common one that we will use. And there are very specific pieces to the sexual assault counselor victim privilege. Certainly commit those to memory. Make sure you have all of those pieces, because if any piece is missing, then the privilege does not exist. So if there isn't supervision, then the privilege does not exist. And I think that that's a, this is all really, it's really important that you get every single piece of the privilege. So parse it out, look at it, and then go ahead and make sure that everyone on staff understands what this privilege is and what the requirements are in order to be eligible to invoke the privilege. Other privileges, so we talked, psychotherapist, patient, again, the guidance really outlines the specifics of each of these. Social worker, client, licensed mental health clinicians, domestic violence victims counselor, and attorney-client. Two notes is the social worker client and the licensed mental health clinicians. The social worker client privilege, we focus more on the social worker client privilege because they have much more comprehensive guidelines for what that privilege is. And so if you feel like we're glossing over the licensed mental health clinicians, it's only because the regs are not as comprehensive as the social worker regs. And so therefore we can get more guidance from the social worker client regs than we can from the LMHC regs that are out there. The other thing that I want to flag is that, of course, the domestic violence privilege is distinct from the sexual assault privilege. These counsel privileges are distinct. The domestic violence privilege is for domestic violence victims, not sexual assault victims. So if someone has been sexually assaulted and you're doing your best and you really want to invoke a privilege, you can't look to the domestic violence privilege if they've been sexually assaulted. And again, I would just caution folks to say, caution people, because it's not going to fly when you're looking to invoke these privileges if you're trying to use one to substitute for the other because you haven't met your eligibility criteria for the one that you really should be invoking. If you're seeing sexual assault victims, get trained as a rape crisis counselor, or, obviously feel free to refer that individual survivor to anybody who you know has the privilege so that can be as protected as possible. The next slide talks about, what is privilege and who does it belong to. Again, this is a really basic concept, but really important in terms of record keeping. Number one, the privilege belongs to the client and no one else. So should you get a records request about something, about an individual's records, it is the individual person's privilege, that privilege does not belong to the Rape Crisis Center. So all that means is that the Rape Crisis Program can invoke the privilege, but should always check with the survivor if the survivor is, if you can connect with the survivor or whatever, should always connect with the person to talk about either, why you want to invoke this privilege, why you don't want to invoke this privilege. And again, if you don't want to have that conversation because you don't know enough about the privileges and about the legal ramifications of giving up those privileges, then feel free to send them to the Victim Rights Law Center, because that piece of it, that analysis of how this works and what you'd be giving up with if you disclose, and what possible consequences could be, we can talk that through with the individual survivor. And I think that we've had some real success talking people through what that analysis looks like. Above everything, of course, the privilege belongs to the survivor. In addition, no privilege is absolute. When I look at this privilege, the sexual assault counselor victim privilege, it looks to me like it's absolute. It looks like, you can't get at these records. If someone says, no way, you can't get these records, it looks to me from the language of this that you can't get these records. Unfortunately, that is not the case. That has not been the way that the court has implemented this particular privilege and the other particular privileges, including the psychotherapist and the social worker privilege. And so what I would suggest to all of you is that the courts do eventually have the final say on what is privileged and what is not. But as a standard, I would suggest to you to treat everything as privileged initially, particularly because the privilege belongs to the client, and if it fits the definition of any one of those stated privileges. When Stephanie and I were talking about this, we sort of talked about how this privilege is like a lot of bark and not a lot of bite. And so you really want to kind of go out there shouting from the rooftops, this is privilege, this is privilege, this is privilege, we're not giving this up, we're not giving this up. Because it is possible that as you're shouting that from the rooftops, the defendant or whoever is requesting these records will back down. Is it likely? I don't know. But is it possible? Absolutely. And so it's really important to sort of come out strongly in favor of the fact that this information is held within your records, and your records are privileged, and therefore, these things are privileged. So, we talk a lot about privilege, and we're going to talk about what is not privileged, and what is privileged. And what is not privileged is the date and the time and the fact of service. Because, so in other words, so if you get requested for records, and the only records that a defendant wants are the date and the time of service that the individual came in for, for help, I would say, number one, still claim privilege, because it's important to just put that initial stop sign up that says, let's stop this right here. You're not getting very much from us, blah, blah, blah. And then the conversation starts. Well, this information, we're only seeking a tiny bit, and it's not privileged. Okay, fine. Contact the survivor. This is what this is. This is probably why they're seeking this information. Call the Victim Rights Law Center. You can have a more in-depth conversation about this. Things that are privileged are your notes, your impressions, your thoughts, certainly what the survivor says. Anything else that really calls upon your sessions with the survivor and your expertise as someone who belongs, who this privilege sort of belongs to. We talked a little bit about as a suggestion, and again, these are suggestions. These aren't these aren't, you must go back, you must do these things, but as we talked about date and time, and I'll sort of give this to you as an example, is the Victim Rights Law Center, our records have been subpoenaed. And I think that we are looking to, and are always looking to, reform our own practices so we can really appreciate what folks are going through as it relates to record keeping. But what we talked about is it may be helpful to keep a separate log for the date and the time and the fact that someone came to you, and then keep your notes and impressions in a separate, not in a separate file, just on a step. So when I think about it, a two-part file, the regular manila folder, and I think about the left side having a log, date, time, and service, yes, no, yes, survivor came in for service. On the left-hand side, all in with a click. Then on the right-hand side, you have all of the things that are presumptively privileged: notes, impressions, thoughts, things that would lead you to a diagnosis, like an assessment of someone. Survivor presents with all of these different types of things in order to be able to assess, the person's health and level of trauma. I think the only caveat that we've discussed about this is, there is a balance. So for liability concerns for your organization and for licensing, you need to show referrals, some sort of diagnosis. And I think that can be really tricky because it goes against some of these bright line rules that we really want to impose. So you want to be sure to have the information that you need for your licensing and for liability. You want to be sure that you have this written down and you have access to it. All at the same time, keeping it apart. I mean, in the same file, because the last thing you want to do is keep shadow records, but in the same file, and restricting some access to this information from the defendant's attorneys or someone seeking to discredit the survivor, with her own words, or with a particularized diagnosis that someone has gotten better from their trauma or whatever. It's a minefield of information that we could be letting out, and I think that we've all been in the situation where it is a really scary thing when we look back at our notes. And again, I say we because this has happened to the RLC. So I can talk from a place of personal experience. We have all been faced with looking at our own notes and thinking, why the hell did I put that in there? Or why did I do that? I shouldn't have put that in there. Now I'm looking at it and I shouldn't have done it. And I think that is a really big thing. And again, it's about a balance. It's about what you feel comfortable being able to implement, due to time constraints, staffing constraints, and all of those things. But again, I think that you never know best until you're faced with looking back at your notes and thinking to yourself, shoot, why did I do that?
And to add just one thing to that too is to think about, when do you not need notes? When should you not be keeping certain information? So if you're keeping information about hotline calls or medical accompaniments for data purposes, you probably, unless someone is an ongoing client and there needs to be that connection, you don't want to be keeping any additional information about who you're working with, what their name is, what other programs you might refer them to if it's just about a hotline call. So that way there isn't that link. And even if you're getting a request for something that is not privileged, you won't have that information to hand over. Because the concern always is that from this information that is not privileged, the defense attorney could then go into court and make the link that, well, then it makes sense they're probably receiving counseling services as well, or whatever, legal advocacy services or whatever that might be. So the less connection between services, the better at times. So if you don't need to keep this information long term, it's better to not do that and just keep the demographics.
And when we get to record keeping and these Dwyer motions, which are motions within the context of a criminal case, what what we'll talk about is the fact that a defense attorney cannot get after information that they do not know. So a defense attorney needs to know the name of the counselor, needs to know that someone sought services, needs to know that information. So if you help them put the puzzle together by, sort of telegraphing who this person is going to, I referred them here, I referred them here, I referred them here, names, addresses and all that stuff, well then, the likelihood of being able to pierce the privilege actually increases because they don't have to go on a little witch hunt. It's just sort of right there. You're basically sort of, it's like the path and the breadcrumbs. You're leading them to more and more information of the survivor. And we've definitely had that, where we have represented survivors and a defense attorney has said, I know that they got referred, and the judge will say, well, how do you know? Well, I mean, because they've only seen the Rape Crisis Center 2 times, and I know that they're seeking, well, but how do you know? Right? And if the defense attorney can't answer, how do you know, then they don't meet the initial threshold that it takes to pierce these privileges. Now, the flip side is, how do you know? Well, I know because I have this note right here that says they referred them to so-and-so at such and such a place, and that's why I know, and therefore it's discoverable, and I can always say it's relevant, and that's why I need this information. And that's probably going to, that's probably going to get pierced. That privilege is going to get pierced. So, why is this all important? And I think that, this is, again, we're talking about the basics. We're talking about the 101s here. But, of course, when I think about the way that these things play out in court, I think, boy, this information can really help a survivor's credibility. Someone is embroiled in an immigration battle, and, defense attorneys in immigration like to claim that, people who aren't documented, they are very, crafty people who go into all these organizations trying to figure out ways to make up things and trying to figure out ways in which to get documented in this country. And I think that we all know that that is sort of colossally untrue. That is a terrible myth, but the myth can get pervaded, and it's unfortunate. But that's why some of these records are really important. It really lends credibility. If we have the date and the time, we can say, oh, the person, never suggested, or the person came in and, gave their story to someone in April, and then not until, January of the next year were they, seeking a U visa or something like that that would make them eligible for, to stay in this country. And so I think that that's a really important part of this. When we were preparing for this, we actually couldn't think of a scenario where if there was not an ongoing criminal case where our records wouldn't at least help lend credibility to the survivor. And so we listed a whole bunch here: immigration benefits, housing, school cases, restraining orders, employment, because, again, without an accompanying criminal case, and again, this is something that if folks want to do a broad brush to the survivor and then say, but you can contact the Victim Rights Law Center, we're happy to do this. If there isn't a companion criminal case and the victim says, I want to disclose X, Y, Z, P, D, Q, well, the only thing that needs to go into that conversation is, here's the possible risks. If down the road you want to do X, you just need to understand that this could come back. If down the road you want to do Y, you need to understand that this could come back to you. And I think that is just, it's actually quite a simple conversation. I think survivors really latch on to the possibilities for the future. And I think a lot of people often say, I'm not going to do that. I'm going to hold on to that right now until I can really make an informed decision. And we've seen that time and time again.
And one other thing to add about why I think it actually is really helpful at times that we have records and that we can knowledgeably talk about as survivors' cases, because we understand sexual violence, we understand the dynamics, we understand survivors' reactions, and we're in a position as experts to frame what a survivor may or may not have done before or after an assault in a way that makes sense, in a way that bolsters, again, their credibility. And that's something that I think is it's very important. It's hard for survivors to find even private therapists if they haven't been trained in trauma-informed care. Often their records may put down facts, but there's no perspective, there's no framing, there's no understanding about someone has turned to substance abuse to help cope with the symptoms resulting from a sexual assault. So we're in a position to actually help survivors in a lot of legal-related cases.
So a very practical point here is if records are requested and the survivor says, you know, yes, you can go ahead and disclose some of this information, do you hand over the actual records themselves? Best practice, no. Best practice is review the records, figure out if you can either do a letter. There is a sample immigration letter in one of the appendices, I think it's B, of the record-keeping guidance. There's a sample letter for immigration purposes, or figure out if you can fill out an affidavit based on the records. So it's all relating to the records, but they aren't the records themselves. You know, and again, I think the reason for that is sometimes our impressions are mixed in with the date and time. You know, sometimes there may be some things that are actually privileged that the survivor doesn't want to go in, but they're mixed in with the stuff that the survivor wants to disclose. And so I think a best practice is it takes a little bit more time, but once you get a template, it doesn't take any more time than it would take to copy the records. It's just about inserting the information. So I think best practice is don't turn the actual records over themselves unless you're specifically ordered by a court or with explicit consent and permission from the survivor after having that conversation with the survivor about what it could mean. Again, you know, to me, having had a tricky balance, you know, with the VRLC and our records getting subpoenaed and everything, I think this is a really important slide, and that's why I put it in there 2 times. I just think that I think that it really is a balance. So despite the fact that we might say it might be a best practice to not turn your records over, you know, do you not have the staffing? Do you not have the time? Do you not have the authority? Do you not have the support? Do you not have the right policies implemented? You know, that's the balancing act of all of this. So really this is just to try to start you, get you a little bit further down the road than you already are. I know that people, again, having talked to a lot of you, have done a lot of it, We're just having a few technical difficulties. Apologies for that. We're just trying to keep this recording, and we're getting a little pop-up that's saying that it stopped recording. So we're recording again, and we're happy to be back. But anyway, so we're just talking about this really tricky balance, and you know how we do appreciate that it's tricky, and we do appreciate that there is a continuity of care that we all want to provide. And it is really tricky. So again, despite the fact that we're just trying to put people on the right path and whatever, we do understand that there are some of these that are going to be just particularly difficult, you know, whether it's philosophically or a regular implementation or whatever. It's just some of these may be more difficult than the others. The documents that we have, the documents that we reviewed were the DPH guidelines in order to try to help manage or, you know, through all of these. The DPH guidelines, the record-keeping guidelines for rape crisis centers, which was authored, just so you know, for frame of reference, which was authored by Wendy Murphy. I think it's a Jane Doe Inc. Sheet. It's very short. It's like 3 or 4 pages. The only thing I want to just call your attention to is those record-keeping guidelines for rape crisis centers, there's a few parts of that are particularly out of date. And so I just want to caution people when they're using that to make sure that they're using the most up-to-date information. So, you know, use the guidance that we will recirculate. in comparison to those record-keeping guidelines, just to be sure you have the most updated information. One of the biggest things is it refers to Fuller, which is a very, very, very pre-2006 case. So I just want to call your attention to it. Just be a little cautious about it. Then there's the sexual assault training curriculum for new counselors and advocates, and then the record-keeping guidance from BARC, which was authored in 2011. So these are some of the things. I think that as a program and sort of in concert with DPH, we talked about some of the things, and I think that we had all come to a relative consensus that as it applies to record-keeping, the most comprehensive document out of all of these is that 2011 guidance. And so I think it does benefit you to use that as the primary resource and use the others, because that guidance actually refers to a lot of these other guidelines or other pieces of helpful information. And so to the extent that that is the most comprehensive, I definitely believe that it is. It's not that there isn't value in these other things. These other things have obviously lots of value, including, of course, the DPH guidelines, which talk about these are the ways that you will keep your funding. But you will see that the guidance also makes reference to a lot of the DPH guidelines, a lot of the curriculums that are out there. So that's just for your assistance. In the DPH guidelines, it does talk about things not to include in records, and it's victim quotations, psychological diagnoses, legal conclusions, counsel interpretations, and records of survivors, friends, or family, and do not keep this in the client file. They talk about things to include in the records, and you'll see the third one down is time and type of contact. And that is, those are all the non-privileged information. So brief intake information on each contact and counseling session. So date, then we have time, type of contact. And by type of contact, I think what they mean is just phone, email. Hopefully you're not texting with your clients. And then any release of information, should someone consent to the release of information. And of course, if there is termination at the outset or all the way after services are provided, then do a termination summary. Here is a little bit of what the LICSW, LMHC licensing standards require. So if you have one of those licenses, you are required to keep your records for 7 years. You actually must provide a diagnosis. You must give psychiatric history. You must give problems and facts, mental status and assessment, changes in diagnosis, treatment plan, frequency and duration of seeing the client, progress notes with assessments, recommendations for additional treatments, and that confidentiality is informed. So you'll see there's a lot of overlapping things with the DPH guidelines and with the DPH guidelines and the licensing standards, but there are a few things that are a little bit different. And so just to highlight those, and again, these differences are highlighted also in the guidance. So if you want more dialogue about how to make an informed decision about, what to follow and whatever, then of course look to the guidance. But one of the big things, and of course this is very difficult, one of the things is the diagnosis and the counselor interpretation. As far as the diagnosis goes, the guidance talks about one particular helpful way of doing it is write about the assessment of the victim instead of a conclusion for a diagnosis. And then you as the expert will understand what the diagnosis is, but you're not sort of telegraphing it all out in black and white, that is. And that helps, because whatever the assessment is, whatever the assessment is for the individual person, that's the information that you're going to use in your sessions, and that's the information that's going to be most helpful. The other piece of this is any of these conflicts or any of these differences, these are questions that can be brought back to clinical directors for your own organization to come to an agreement on philosophically. What does it mean? What it means. I think that it's really about being cautious and having the conversation as, like we always talk about, it's really important that our clients and that our survivors have informed consent. To me, it's kind of the same thing. It's really an informed conversation so that whatever decisions that you do make, whatever implementation that you do implement, you understand the reasons and the rationale behind it. And that is really important. Understanding why you're making these decisions and going forward, I think that is really important.
And as a professional, particularly for the person that you're counting on, whether it's one person that you have licensed on staff or several, that they understand their licensing requirements and they understand what you as an agency have decided for all those reasons that Colby was talking about, and they feel comfortable with it. There may be some professional risk that it feels like they're taking. It may feel a little, uncertain at times or uncomfortable, but it's something that I think is really important that your staff is fully aware of and fully willing to take on, because they work at a rape crisis center, they care about the mission, they believe this is the best way to serve survivors.
So a few, just a few housekeeping things. It looks like the guidance was sent to the directors yesterday and to anyone who registered for the webinar, and we can do another one if folks, if maybe check your spam or something like that. Maybe it got caught up in there. Also, that the guidance document was, just so folks understand this, and it doesn't seem like BARC is just trying to be the director of everyone and whatever. DPH sponsored BARC to put together this guidance document to help work with the DPH guidelines. And so, it was because the DPH guidelines were shorter and this was a much more comprehensive thing, it went into a lot more things in detail. And so to the extent that you do defer to it, I think DPH does fully support the use of the BARC guidance, this guidance document, because it was sanctioned by them, and it was really meant to help clarify some of the other, the issues that were not either dealt with or maybe were not clear in the guidance. So there it is, how to reconcile conflicts. Look to the 2011 record-keeping guidance. Again, it's like in preparation for this, I've been, a few days reading it, and just thinking to myself, this really does have everything in it. That's really good. Okay, great. And so I really think it's going to be really, really helpful for folks to really rely on. I think one of the things in interviewing a lot of people, there was a few places in the guidance that, whether it was a rape crisis center director or certain staff counselors, that they really found helpful. And so we wanted to highlight those pieces of the guidance that your fellow programs felt were really helpful. One of the things was what things to consider when deciding whether or not to document it. Again, we're trying to give you specific pages in the guidance to show you where it is, and to help you bring the possibilities. That said, there's the guidance does talk about this a lot, and does actually provide you with, with a landscape of how to talk about this. So I think that will sort of become clear. Yes.
Just to add one thing, even though we're saying what should I consider through all of this, what the hope really is that as an agency, as we've talked about before, you come together and you become as clear as you can, although individual situations come up all the time where there's not a specific answer, even with the policies you may have put in place, but that this is an agency decision. That there are some things that are very clear that are written up that the agency feels comfortable with, and that there are certain people on your staff who other staff can go to receive that guidance if something's feeling like, oh, this case feels really complicated, I'm I'm worried for a lot of different reasons about our liability, about the client's safety, that there's someone who can help other staff think through what we as an agency should be putting down. That it should never be just an individual staff decision. It should be something that makes sense within the organization.
Again, more, in an attempt to help any individual person and an individual counselor and the organization, bright line rules are always great. Certainly it's like what, we live by, and it would be great if there were all of these bright line rules. At this point, there are some things that, the word never, it is a very bright line rule, and of course, you still need the okay from the organization to make sure that it fits philosophically with what you're doing. But here's some things that could trap a survivor into a statement. Victim quotations, legal conclusions if you're not a lawyer, survivor sexual history, and any, like opinions from the counselor. Not so much even a professional opinion, but, I think we've all dealt with people who have serious mental health issues. And there is, and talk about this, I think that there's a way of documenting mental health issues without saying this person is totally crazy. And I think that when we talk about things to never document, we just want to be mindful of what may come out and be harmful to the survivor. And I think that's what we're getting at here. And again, so it's knowing what Stephanie was saying before, being experts on this, knowing what we all know about the neurobiology of trauma, memory difficulties, where someone is in trauma, if they're acute, not, right after the assault or the rape. Taking all of those things into consideration, thinking about those things before writing them down based on everything that we as experts understand. I think that, again, things to ask yourself is, whether or not looking at the documented evidence that you have or the documented records that you have, would you look back at them and say, I wish I hadn't done that, or I wish I hadn't put that down. I shouldn't have really done that. I see how that could really harm the survivor. And in sort of same suit, a survivor may say to you, I know I should have left at that point, but I didn't. That's the kind of stuff that can really come back, and someone who is not an expert in this field can really twist those words against the survivor and make it a really difficult and a really challenging thing for the person. Let's see. Always, consent is really important. Any rights, limits to confidentiality, for example, we're going to get into some of the things to document, and we're going to talk about suicidality and duty to warn and mandatory reporting. And I think some of the things that you need to document, some of the things that really trump, survivor needs or whatever, is some of this liability stuff. And and so therefore, this is a list of some of the conversations to have. What should I always document? Again, date and time of sessions, of course, it's not privileged, but any release of information, any decisions that you make that sort of go against what maybe the standard of care would be, or if there's a mandatory reporting issue, if there has to be termination. I think all of those things, because it feels like you're kind of like a salmon swimming upstream. Anytime you feel like you're swimming upstream a little bit, I think that is the more protective way of viewing your records and the more protective way of helping you, protect your license and protect the organization from what could be liability.
I think it also can be a really helpful decision-making process, too, to go through that and think through how am I going to document this and why exactly did we decide that we're going to break confidentiality or whatever it might be for whatever reason. Really thinking through with your colleagues and thinking through your professional, again, obligations, and also to the survivor, but also to yourself and to the agency, that it always helps to kind of have to write that down in a way that will make sense if you go back a year from now and figure out why you made the decision you made.
Again, it's kind of, we know that you've started these conversations. This is really just helping guide in further conversations. And of course, the intent is that you continue to have these conversations. And I think that's what everybody wants. What depends on the circumstances? And again, this is definitely something that there's that balance. There's record keeping, there's liability, there's professional licensing, and there's survivor continuity of care. So you really want to think about, why you're documenting something. Precise wording is important. Again, as I said before, if someone has mental health issues, the last thing you want to do is, let your own personal pieces, not your professional pieces, but your own personal opinion come into it. This person's crazy. I had to cut off service. And again, I would, we're all service providers, so I can appreciate the feeling, the way that feels. This person is incessantly calling. I can't get this person to stop. I can't seem to help this person, kind of thing. But again, there's some precise wording that you might want to use. And again, I would say really look at the guidance. And the last thing that's in bold is always inform the clients about your record-keeping policies and address any concerns that they have. Again, any of these record-keeping issues comes down to a privilege, and the privilege belongs to the client, to the survivor. And so really having informed consent over what those policies are, I think is a hugely important piece. And not for nothing, but I think we've all worked with enough survivors that you can say that if they're at the right point in their healing, that they can really understand what it means to, have the consent, to empower the person to say, yes, I want this because this is going to be good for me, or no, I don't want this out there because I know this is going to come back and harm me. I think that can be a really empowering thing for a survivor. We're going to get into a little bit of the nitty-gritty of the things that you definitely should document. Issues of suicidality. What are your obligations? Should you document anything? And what if information is detrimental to the survivor's legal case? And what to do when you're faced with someone who you believe is suicidal in your professional opinion. So go to page 72 of the guidance and read it over. It talks about what is the assessment? What is your professional assessment of the likelihood that the client is suicidal? What are the precautions taken by the counselor? In other words, this is where you are fighting for your own, for your own protection. And by own, I mean, of course, your organization and your personal licensing. And what protects you from liability is documentation that answers the following questions. What did I do? Why did I do it? And on what basis did I reject alternative ways of responding? And that is basically in the terrible, awful circumstance that someone does commit suicide after you have spoken to them, you have a trail of your information, which you believed wholeheartedly at the time, was the right thing to do, and this is all the information that you've given to the people. And I think that is hugely important. And of course, no one, and no matter what kind of legal battle you get into post, post any of these terrible situations, documenting this is super important because you'll be able to rely on that as the rationale for why these things happen. I think that's big. You can also see Appendix B in the suicidality assessment. This is located in the guidance. This is just a one-sheeter that you can include in your own note keeping, so that you see that there's a supervisor signature on the bottom, a counselor signature on the bottom. We're going to get into supervisors reviewing notes, and we're going to get into that in a little bit. But these are the things that you really, these are the musts when you're doing suicidality assessments.
And again, the reason for a document, it certainly doesn't have to be this. I mean, it can be whatever you feel your organization works for your organization. But the thought behind it is that, again, you don't want this to be an individual on staff assessing everything on their own and doing it in yes, their professional opinion, but not having the whole context of the agency and what you believe as your philosophy is important. So this is just a way to make sure that it's uniform, that of course it's going to look a little different from staff member to staff member, but that the basics are always going to be uniform about how you respond to suicidality and how you document it.
Duty to warn. Do you have a duty? Has the caller made an explicit threat to kill or seriously injure someone? Is the threatened person readily identifiable? Or do you have a reasonable basis to believe that an individual with a history of physical violence presents a clear and present danger of killing or inflicting serious bodily injury on a person? I think that we'd all like to read that and say, I would definitely do X in this situation. And the reason for bringing this up is because as you read this very serious language, you want to have a policy and a protocol for an issue like this. And that is why you want the record keeping for this. So we'll go to the guidance again, pages 73 and 74. In cases where you believe there is a duty to warn, what do you need to document? The reasons why you determine that you did not have a duty to warn. If you determine there is not one, any consultations made, what reasonable precautions would you take to protect or to warn the individual? And I think both of those absolutely, whether or not there's a duty to warn or whether or not there is, a supervisor's signature is of utmost importance. And no matter what the initial policy or protocol becomes, I think that this is one of those bright line rules that you want to have a supervisor's signature on this, on the suicidality issue also, because like Stephanie was saying, number one, you don't want this to be just on yourself, not just for your own mental health, also for the liability, for your own licensing, but also because if you do have a supervisor, ultimately, and you make these decisions, it could fall, the liability could fall on the supervisor and not just you. So I think that you want the supervisor's input on things like this. And here's the duty to warn assessment. Again, it's located in Appendix B in the guidance, and it takes you through some of these questions in the narrative.
And one thing to add that I think it's just as important when a situation comes up where you're at least doing an assessment for duty to warn or suicidality or mandate reporting, anything that feels out of the norm, that sometimes it's just as important to document why you didn't act and or why you did act, but why you didn't act. So it may come back to you at some point that someone says, oh, this person was suicidal or they were threatening someone, you didn't do anything. Well, if you have written down in your professional opinion why you decided to not do that, that there were certain things that were presenting in the case, that you were working with the survivor and figuring out a different way to go about something, whatever it might be, if you have that written down, then you have some protection around that as well. So I do think it's very important to also make sure that you're deciding why you're not doing something and to document that and to make sure that it meets your professional standards.
Whether or not to breach confidentiality, right? So this is all about record keeping, privacy, confidentiality, and I think that these are just some of the areas that some of the conversations that you want to have. And of course, you'll see that the last bullet is the signature by the supervisor. And again, I think that we can't stress that enough. The funding for our organizations or whatever may be low. We may need to take on people who are licensed, who are not licensed. We may be really relying on supervisors. this is all really important. Hotline versus not hotline. A supervisor really needs to be involved in these decisions. And I think anytime you're doing something out of the norm, like breaking confidentiality, that's really the most important time to document it. Like even out of the norm feels out of the norm in cases of mandatory reporting. Document it. Document. And then, think about when you're documenting something, think about what happens if someone comes back and says, why did you break confidentiality? And use the specific reasons to document it and be clear on why you did that. And that is, of course, for liability purposes and for, professional liability and your organizational liability. Some other complex situations when more additional documentation would be beneficial. Again, page 75 of the guidance. Be really clear. I think that is something that in our harried lives and our, in our challenge to serve more people and to help more people, and the phone is always ringing off the hook, and, we feel, or certainly I can say I feel distracted a lot of the time. So, clarity isn't something that we always have, but when you do get it, really think through these things. If you have clients who are not safe for you to be working with, if you deny service, it's okay, but describe why, because those are sometimes the clients who might come back to, either request services again, and then you have a nice record of why you had to deny services in the outset, or, should you ever leave your post as counselor, someone then, it's not just one person has the institutional knowledge. That institutional knowledge is shared with everyone, and that's what good record-keeping practices can help you. Mandatory reporting. So here's the certain situations where rape crisis counselors in Massachusetts are mandated reporters. They are required in these cases to report suspected cases of abuse and or neglect. And I think that, we are not, this is, obviously everybody knows mandatory reporting is a minefield of information, and we're not going to get into the very specifics of it. However, what we will say is this is really about, the guidance talks a little bit about mandatory reporting, but it's really about identifying yourself as a mandated reporter and what are the requirements that as a mandated reporter you need to do. And again, you need to assess the situation, and I think that assessment is a really important part of this. A lot of us, and Steph's just going to talk about DCF training that they had, but DCF will tell you, well, if you file a mandatory report on a kid that's under 18, but the assault happened by someone who was not a caretaker, we're just going to close the case anyway. And so I think that there's some assessment there in terms of, where do you want to put it in your notes, what kind of mandatory reporting do you need to do, and what are the possible consequences of not reporting or reporting in circumstances like this where you know that it is not going to go any farther.
And I think it's just, I think some of you were probably at the meeting for rape crisis providers when DCF presented a few months ago, and they were really focusing on how they've kind of changed the thinking over the last few years for domestic violence situations, and it definitely corresponds to a lot of sexual assault cases. And I think for rape crisis centers and other agencies like us, we don't always automatically report if we're hearing about something for someone who's under 18. We may do more of an assessment like Colby was talking about. There may be other factors that come into play about whether we're going to report or when we're going to report. So again, I think it's just really important to feel confident that this is your protocol as an agency, this is how you do the assessment, this is how you document whether you're reporting or not reporting, and why you're reporting or not reporting. And so being clear for yourselves and then being clear when you document, I think, is a way to protect yourselves, to make sure that you're doing right by the survivor that you're working with, and that everybody feels like they're on the same page about what's happening and why.
Some of the tips, if you make a mandated report, keep a copy of it. If the report is connected with ongoing clients, keep it within the file. And mandatory reporting documentation should always be kept in a separate file for at least 7 years. And I think that's just That's just record-keeping requirements. There's more in the guidance, pages 69 and 70, and you'll see from here, this is the mandated reporting decision-making assessment. So it sounds like you've even had further information on this. If you want to add stuff, this obviously was made in 2011 before DCF. So to the extent that you use this as a template, you can feel free to put some additional information there if you have learned some new things that are really important to you for purposes of mandated reporting. Okay. So again, in interviewing a lot of people, you all helped us so much. We, probably 2 years ago now, I think we sent out a really comprehensive survey that most of you filled out, and we really appreciate it. We have really tried to gather as much information from you as we could to make sure that we were responding accurately, but also really responding to your needs, because we understand, again, having myself personally been put in the situation where our records have been subpoenaed, I know, even being a lawyer, I know how scary that is, and I understand that. And so we have had some really common questions to come up over and over and over again. And so we'll go through just a few of those. Just to let folks know, we're pretty much right on time. I think we have about 15 more minutes of the webinar. And so I think that we'll probably get through the webinar. Again, I just want to say if folks have some questions, this may be the time to send them to us to the extent that we have a few minutes after, and we can answer any questions, meaning a few minutes after we end the presentation. To the extent that you may have them, we'll do our best to reply to them if we feel like they address kind of the whole group. So here's some, answers to common questions that we heard from you. Here's one of them. Our advocates can only provide services under the supervision of a licensed provider. Her license requires her to keep detailed notes about clients. Does an unlicensed rape crisis center advocate jeopardize the supervisor's license by not keeping detailed notes? The short answer is yes. We are going to go here. Best practices. Counselor supervisors should treat the client like your own, because in these cases where someone is unlicensed, liability falls to the supervisor and not to the individual counselor. So when you're talking about liability, you're talking about licensing, and you're talking about your organizational liability. Sign off on individual counseling records. I think I heard a gasp from everyone, even though everyone is muted. But I wanted to say, we were talking about this, and we know that this can be really challenging. Or, some of you are already doing this. But individual counseling records, this is how you get those conversations and those protocols and policies. Really, you can deal with them. If there's an individual, a counselor, who keeps writing down quotations, at the very least every month or something like that, you can review their notes and you can say, these things can be detrimental. You can correct any of the wrongs that have been made, any of the mistakes that have been made. If you see that the mandated reporter, didn't report, you can correct that. So I think that that's really important when you're talking about some of these. It feels like a lot. Oh my gosh, a supervisor has to sign off on individual counts. Feels like a lot. And it is a lot, but there are some things that really help reduce the amount of liability and reduce the amount of exposure that your counselors and your supervisor can get by doing these things.
And it's definitely to feel like the last thing you want is to receive a subpoena and go to a file, and this has definitely happened for us, numerous times where we've opened a file and we were a little horrified by something that was written, something that was included in the file, and now we're thinking, oh my God, so we've gotten this subpoena, now we have this file, and we have to send in the file as is once you receive the subpoena, and this is horrible. Mm-hmm. So anything you can do to minimize that happening, and we have started the practice of having supervisors look, and we recently received a subpoena, and we went to look at the records, and it was a file that fell through the cracks and the supervisor hadn't seen it, and there were some things in there that were a little iffy. So it's not foolproof, but at least it makes it a little bit easier, because there are certainly times now when I go look at files and I feel like, okay, this isn't necessarily going to help the survivor, but it's certainly not going to hurt them either. And that hopefully is the goal. And one other thing to just clarify too, when we talk about supervisors needing detailed records for their license, again, this is a risk analysis for the supervisor and for the agency. So it doesn't mean, detailed can mean many things. You want to make sure you're following your mandates, you want to make sure you're following the law, but it can be individualized, and it just needs to be that the supervisor feels comfortable and confident that it's still following enough of the rules that everybody is safe.
Mm-hmm. So here's another situation that we have had come up a few times. And through the surveys 2 years ago, we had this issue come up quite a bit, actually. So the situation is, I'm an executive director of a rape crisis program. I asked the counselor to sign an affidavit saying that we don't have any records for a specific victim, but the counselor wouldn't sign the affidavit. What do I do? And as the executive director, this is a really challenging situation. You want to believe that your employee, your counselor is doing all the right things, but what could be the motivation for someone not wanting to sign an affidavit saying that there aren't any records? And this is where we say one of the biggest bright line rules, the most important bright line rule, is never, ever, ever keep shadow records. And a shadow record, for those of you who know, terrific. For those of you who don't, is you keep 2 files for a client. One file that you show to your supervisor, that you bring to case review or supervision or something like that, and then the other file that's just yours, that may help you remember particularized things about someone. You may think that you are doing a service to this person because you are able to now recall that they were raped when they were 4 and 6. They were a victim of incest, and you're keeping that in the other file. But rest assured, when records are requested, they're not just requesting records from the organization. They are also requesting your personal records. And if you have shadow records, these are always, and I think I can truly say that because I've seen some shadow records, these records are always the records that you don't want to get out, right? Because if you're a counselor, you're writing these shadow records and you're thinking, this is awful. I need to keep this in a separate place. I need to keep this. Nope, you don't need to keep it, right? Because, so recently we have, recently we have come upon a defense attorney, and I think they're getting much more savvy in the context of a criminal case, where the defense attorney, his wife was a clinical psychologist, and she suggested to him, and we heard this through the subpoena process and whatnot, that psychologists and clinicians always keep their own records. So not only did this defense attorney request organizational records, but they said, we request your organization records and any and all personal records that were created in the course of seeing this individual in your professional capacity. So be careful. I think, be careful. What you need long-term should be put into the actual file, and what you don't need, either bring to supervision and decide what you're going to do with those notes, shred them, do, whatever you need to do, but it is not okay to shred those records after those records have been requested. It is okay to review those records, to make new notes on them, to revise them, to continue to revise them, but your chance stops at when you receive a request or records, because that is, you're tampering with evidence and you cannot do that. And you know, sending an executive, if you're a counselor out there, sending an executive director in for the executive director say, no, we don't have any other notes, unfortunately, you know, you're basically setting the executive director up to perjure him or herself up there on the stand saying, we don't have anything. Best case scenario is we don't have anything and it's true. Worst case scenario is executive director goes up there and says we don't have anything, but you as the counselor know that there is actually something out there, and that's a bad situation. You know, here are the types of records requests. You know, I've been talking a lot. We just thought it would be good to do a little review. I've talked a lot about within the context of a criminal case, and for those of you who haven't heard of this, they're called Dwyer motions. It is when a prosecutor brings a case against the defendant, against the perpetrator, and the defendant, the perpetrator's lawyer, asks for personal records of the defendant. I'm sorry, excuse me, of the victim. And it's called the victim in this particular case, and I'm using these very legalistic terms, and I know that many of you, if not all of you, know these legalistic terms, but I'm just explaining them. You know, the victim in this case is called a third-party witness because the victim is not a named person in the case. In other words, these records requests do not go directly to the victim. They go to the prosecutor, and then it is the prosecutor's obligation to then send those records requests to whomever, to the survivor, to the Rape Crisis Center, or whatever. And so what's really difficult about this is, of course, we have these two competing types of records requests. One's where within the criminal case, a victim gets records subpoenaed for counseling records. And then the other one, which is super helpful to a victim or a survivor, is when they request their own records for proof of counseling so that they can access benefits, access immigration benefits, you know, access school accommodations, or if they've decided they don't want to do anything within the criminal context, even to go to a restraining order, you know, again, with the consent of the victim, you know, with having had the conversation with the survivor, this is what you need to think about. To go in there and to say, I have an advocate from the Boston Area Rape Crisis Center, from Independence House, and you know, and I'm getting counseling from them, and my counseling, here it is, started on the day after I'm alleging this rape occurred. That lends credibility to the individual story, and I think that is really helpful. When a survivor, when a defendant requests records, as we talked about, it's under Dwyer. You know, the records that get requested can be medical records, can be counseling records, can be, you know, personal records, anything. When you're talking about a defendant's attorney in the state of Massachusetts, you are talking that they want to use everything against the victim, anything that they can find. And you know, probably 6 years ago, we had a case where a defendant asked for records because the defendant found out or knew, because he knew the victim, that she was bulimic. And the defense attorney was tying bulimia at age 11 to a need for attention, and therefore the motivation to make up a rape later on in her life. I just, you know, I think that all of you understand this, but I think that, you know, the defending someone in court as a defendant's attorney, there's due process, there's all these protections. You know, you have to be a good advocate, a good attorney, but I don't think there's a ton of scruples as it comes to finding out information of a victim or of a survivor. And I think you just have to be very mindful of that. I think, to me, contacting the survivor, if there's any way, shape, or form that you can, think about the scenario that I gave in the very beginning, which is contact the survivor, think about it, a survivor and attorney, a rape crisis program and attorney. the prosecutor, the attorney. That's 3 against 1. You know, if a judge goes out there and says, whoa, you know, what are all these people doing? A judge may see it as a more serious job to maintain the privacy and the privilege of those records versus just saying, well, I mean, it is relevant, you know, this kind of willy-nilly analysis of, you know, a defendant does have rights to confront his accuser, you know, I really feel like it might be unfair. No. It's like all that goes out the window if you have 3 people pounding on the desk, or 6 people for that matter, pounding on the desk saying, no, 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 this information is privileged. We have to maintain it as privileged. These privileges, you know, are stated privileges for a particularized reason, and this information is all presumptively privileged, and therefore you have to maintain it as privileged. I think when you invoke a privilege like that, there is a showing of real strength and empowerment, and it's terrific for the survivor, and I think in court you just can't underestimate how that looks to a judge.
And as record keepers, when you do receive the notice that this hearing is going to happen and that there's this request for records, it goes very quickly, the time between when you receive it and when you need to be in court. So my suggestion, just a little off topic, is that as much as possible to try and build some relationships with attorneys in your areas that are your go-tos, that you can call them and say, look, I received this, we need to go in, can you represent us as an organization, as the keeper of records, so that you're not scrambling at the last minute. I mean, I definitely, every time we receive a subpoena, there's always that moment of panic, right? Who's going to represent us? How are we going to do this? So the more that you can be prepped beforehand, just like the more you want your records to feel confident that you're going to go to your records and they're going to be okay. You also want to feel like you can go to someone who knows what to do and how to respond quickly.
Yeah, absolutely. And you know, just sort of transitioning, why does a survivor request records? You know, here's a whole bunch of things, but I mean, truthfully, again, as we were prepping for this, there is really no end to why a survivor might. I mean, you know, if someone might want it for their family, you know, we know how judgmental people can be, and we know whatever. And sometimes survivors think that showing someone the actual evidence that they've gone out there and done this can really help. Certainly legally, it can really help. It can help in immigration status. It can help in benefits. It can help in housing. And of course, the one thing that we haven't talked about are tort suits, which are just lawsuits that the survivor, him or herself, or her or himself, brings against the perpetrator or brings against a third party for not protecting them, for not having the right lighting, for doing any of these things. And in those cases, a survivor's mental capacity and emotional well-being, damages, all of that stuff, all goes to how much money a victim can ask for in those lawsuits. And so I think that that is a really big thing. So in that way, you know, you want some of those records. I think all in all, best practices, respond to a request for records. I would say maybe contact the survivor first, respond, you know, second, you know, making sure that even if you don't get in touch with the survivor, you're still claiming, these are our records, we're a rape crisis program, all the people here have this rape crisis counselor privilege. And, you know, I think to me, and to Steph, as we were talking about this, it's really, if you can't reach a survivor, always assert the privilege, just in case. Because you don't want to be the day after you don't reach the survivor calls you, which of course you know would happen, because that's just the way things go in our work. But you know, always assert the privilege on their behalf. It's a really, really, really good idea. It keeps you safe. You know, highlights, supervisors really take an active role in reviewing the notes and helping the counselors understand what they need to do. Never keep shadow records and personal notes. Don't ignore requests for records, even if, and let me say this because I understand this, even if in the past you have, because, you know, I've heard from plenty of people, oh yeah, just throw them in the trash. Defense attorneys are getting a lot more savvy, a lot more aggressive. I really can't underestimate that. Again, VRLC's records, they were never an issue 10 years ago, never an issue 5 years ago. Now I feel like there's an issue all the time. I just think they're really pushing the envelope. People are getting more savvy about this. and, you know, of course, the importance of the survivor's privilege. You will all be excited to know, as we are very excited to say, that at a MOVA forum, we're also doing a little bit of this privacy and confidentiality and record keeping. It is now set, we just said it yesterday with Nicole from MOVA, November 14th. November 14th of 2013. It's going to be held at the Worcester Public Library. It's from 2 to 4 p.m. And we're going to be going over privacy and confidentiality. We didn't have the date when we actually had this, so I'm just letting you know what the date is and whatnot. This webinar is also available, including technical difficulties, online and with DVDs provided and will be distributed by DPH. We are done. It is 11:33, exactly 90 minutes after we got started. We really appreciate everybody participating. We have had 0 attrition. No one has dropped off. Thank you very much for being patient and listening to us. And truthfully, we hope that this has helped, and we hope that you'll look to the guidance. And, you know, we really hope that you get those policies and procedures to make you feel comfortable and you feel confident in the decisions that you're making in the organization.
And thank you. And we recognize that it's a difficult process. It's a long process, but hopefully it will feel like a worthwhile process to you so that you have a little bit more peace of mind when a subpoena does come your way.
So thanks, everybody, and we're going to be signing off now.
Bye, everyone.
Thank you. Oh, it's a little treat. Bye.
Stop it.